My second argument is on the Fifth Amendment grand jury indictment and that it applies to states. The Fifth Amendment requires indictment by grand jury specifically to protect against malicious prosecution. Hamilton in the Federalist Papers number 83 says, "The excellence of the trial by jury in criminal cases consists in the strong check which it places upon the arbitrary discretion of the judge and upon the caprice of rulers. It is a barrier equally against the despotism of the monarch and the tyranny of popular magistrates. The unanimous suffrage of 12 men of the neighborhood and of the same rank with the accused can alone pronounce the dreadful sentence of death or confinement." The state may argue that under Constitution, the Washington State Constitution that is, Article 1, Section 25, prosecution by information, which says, offenses heretofore required, if you notice, they noticed that it's required, to be prosecuted by indictment. It may be prosecuted by information or by indictment, as shall be prescribed by law. Shame on you, Washington. The Supremacy Clause says you can't do that. But in fact, here we go, Article 6 of the U.S. Constitution, known as the Supremacy Clause, states, "The Constitution shall be the supreme law of this land, and all judges in every state shall be bound thereby." And the 14th Amendment prohibits states from making or enforcing laws that abridge the federal constitutional rights. It specifically says, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States." In Miranda v. Arizona, where rights are secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Marbury v. Madison says that the Constitution of these United States is the supreme law of this land, and any law repugnant to it is null and void. This case was created in 1803. It was the very first Supreme Court case ever made, and it set the precedent that case law was a part of the check and balance system to keep the three major forms of government in line with the Constitution. The state may argue that in Hurtado v. California, which held due process does not apply, or due process does not necessarily require a grand jury indictment in state prosecutions. Shame on you. But in fact, this ruling reflects judicial interpretation,